Just what we consider the relevant articles at issue here. If you'll turn to, after the preamble, you should have a page that says Article 8. And based on the grievance we just looked at, are you aware that the union cited to 8.1, 8.3, and 8.7?
Yes.
And in 8.3, it references the Florida Law Enforcement Officer Bill of Rights, correct?
Yes, it does.
Okay. And you've seen, well, go ahead and skip that for now, in the interest of time, Chief. The notice of final discipline that you issued, which was your tab 22, at this time I'd like to move that into evidence.
No.
Okay. All right, Chief, in my remaining few minutes, I'm going to try to move quickly as I can. When you wrote your final report, I guess we'll call it, was that your final discipline? Do you send that to someone to review, sir? I believe you said on direct.
This actual report, there's a final proposed discipline. Do I send it to someone?
Yes, sir. Do you have it reviewed by anybody?
Don't believe you do. I think it goes into the file.
Okay.
I don't know, this may be part of the packet that gets sent over to the manager.
Okay.
I don't send that over.
Okay.
It's going to be the deputy chief.
Do you review the final IA report before it's finished?
Yes.
Do you sometimes send that to outside counsel to review?
Yes.
Now, I'm not going to ask you.
I haven't, but
Okay. I'm not going to ask you to disclose the content of any communications with counsel, but this is more of a yes or no. To your knowledge, was the final proposed IA report in this case sent to Mr. Benton Wood to review and evaluate?
yes, I believe it was.
Okay. To your knowledge, did he give some input on the final report?
Yes, he did.
Okay.
To my knowledge.
And would that have been the final report that we have, it's City's Exhibit 5 in the black notebook?
Yes, that's the final.
Okay. Would that have been the one that you think Mr. Wood may have given some input on?
Yes.
Okay. Just one other thing about an exhibit. You'll turn behind tab 15, exhibit 15.
Which book?
The white book, I'm sorry. 15. On direct examination a few minutes ago, you said that you had not, you did not give any direction as to the outcome of this IA. Is that correct?
Correct.
But isn't it true in this email here on July 2nd of 2019, you make a recommendation that something should be omitted from Lieutenant Mathis's testimony, correct?
I wouldn't characterize that as that. I qualified the question. I'm asking a question.
But you are in fact, I think that should be omitted with a question mark, correct?
I'm pointing out a particular part of the review I was doing.
And then near the end of your direct testimony, you said that you did not have a predetermined outcome in this case, but that you had dealt with that same allegation in the Malero arbitration and with the ethics complaint in this case. Do you recall saying that, sir?
Yes, sir.
Do you recall in the arbitration award in this case, in the Malero case, it became apparent that there had been some violations of the Officer Bill of Rights as determined by the arbitrator concerning the conduct of Lieutenant Milan. Do you recall that, sir?
I don't
He didn't meet the two-part steps, the same two parts required by 112.533 of the Law Enforcement Officer Bill of Rights, just as he didn't do it for Officer Goins, correct? He didn't do it for Malero, and he didn't do it for Goins.
Yeah, that was the testimony here today, yes.
Okay. If you'll turn behind tab 34, since he asked you about the Malero arbitration, I'll just spend a moment. This is the arbitrator's award in this case, in the Malero case, from Kristen. 34 in the white notebook. You recall, this award came about just in March of this year, 2021, correct?
That's correct.
And this was from Christopher Schulman, was the arbitrator. You recall that, sir?
Yes, sir, Mr. Schulman.
And you recall that some of the same information that has come out in this case about what Lieutenant Juan did or didn't do came up in that case, specifically about not properly signing off on the IA report.
Yes, some of those are similar.
Sorry,
Some of those issues are similar.
Okay? Just briefly turn to page 19 of this document. Page 19.
They are not numbered.
In the upper left corner, after you get past the first page.
Okay,
Try to-
page 19?
Yes, sir. Tell me when you're there.
There.
Do you see in the last paragraph that Mr. Sherman wrote, as to element 4, whether the investigation was fair, I am troubled by the violations of the Law Enforcement Officer's Bill of Rights committed by Sergeant Milan here, the failure to preserve the video and audio tapes of Mr. Kidd's interview. And he goes on to say, the failure to add the veracity language at the end of the report as required by Florida Statute 112.533.1A1. You see that, sir?
Yes.
My question about that in relation to this is, once this award was issued in March of this year, you read this decision, correct?
I did.
In fact, you weren't happy about it, were you?
Objection, relevance to this proceeding?
Okay, you had your community information specialist, Chris Graham, issue a statement right after this decision was issued, correct?
Objection, relevance to this proceeding?
It goes to notice that they,
In terms of the aftermath of,
I'll withdraw it, I'll move on, if that will save.
so I don't want to cut off the questioning. I've heard about Bolero for 2 days now, and I was puzzled, well, we're going to see the arbitrator's award, now we have it, and thank you for that. But I don't know what Bolero was terminated for, what he was reinstated for. I'll read it now, but I don't know how it compares to this one.
Okay.
If they're apples and apples or apples and oranges. And also how the city dealt with the award, I don't really think it's germane to this case.
Okay. I'll move on to something else. At least one of the issues that was before the arbitrator, would you agree, just as it is in this case, is whether the officer's rights were violated under the Law Enforcement Officer Bill of Rights.
Yes, under the required Florida statute 112.533.
And that's one of the very things that has been raised in this grievance by citing to Article 8.3 of the collective bargaining agreement, correct? Remember, I had you turn all the way to the front of the tab, and I said, would you agree the grievance does cite to Article 8.3, which references the Officer Bill of Rights?
It references it, but it says interrogations of employees under investigation for conduct which disciplinary action may result shall be in accordance with the Florida Law Enforcement Officer Bill of Rights.
Okay?
It doesn't, talks
recall that the arbitrator was,
Hang on. I'm looking at the contract too,
yeah,
which is arbitrator's exhibit number 3, our joining. So
Yes, sir.
Exhibit I entered.
yes,
I'm on page 18, paragraph 12.9.
12.9.
It says, no decision of any arbitrator or of the city in any one case shall create a basis for retroactive adjustment in other cases. I don't know what that means, but I'm worried about arbitrator Schulman's decision in the Valero case binding me in this case if an arbitrator is awarded one case.
Okay, I see what you're, I think we can brief on that, but I'm not offering this opinion for purposes of it creating a precedence or binding impact on this decision. I want to make that clear. What I'm trying to lay the predicate and foundation for is to illustrate that the city was on notice after this decision about its process and procedure.
Okay.
Yes.
That-
I'm going to object at that point because this decision occurred years after they were done with the internal affairs investigation report here. It sounds to me like it's being offered to show that because something bad happened in the past, it's likely that they did that same bad thing now, which is an elementary rule of evidence. And you can't, that type of evidence isn't admitted.
But what it's admissible for, though, what we're seeking its admissibility is to show, as I asked of Lieutenant Milan, and I'm about to ask the chief, is that once they were on notice that this is a problem, and they fixed it with Krashenko. They still haven't done it for Officer Goins since March 12th of this year, when this decision came down. They still have not done anything to correct the closeout of his IA in a proper legal manner. So that's what it's being proffered for.
Okay.
At this time, I would like to seek the admission of Exhibit 34 into evidence.
I object for the reasons that I just objected, and to counter his notice argument again. Notice wouldn't be relevant here because the decision was passed down well after the events that transpired here, including the
I'm going to overrule the objection. I'll let it in. Because of the way it preserves, having excluded any item of evidence in this case. And I've heard so much about Valero. So now I want to see how that,
Okay.
other than this civil rights issue,
Okay.
which I know is significant and by statute, if Valero facts in that case and the termination and award are similar to this case.
And Chief, trying to move on here in the interest of time. After the impact of that decision, it appears, as we heard testimony from Lieutenant Milan, that there seemed to be some change in how the IA department, IA division was closing out reports. Is that correct?
Yes.
And specifically, if you'll turn to tab 33, this would be the Krashenko, the excerpts of the Krashenko IA. And you recall, Chief, I was here for your, I guess, show cause hearing for Officer Krashenko.
Yes.
And if you look at the last page of this exhibit 33 that's been admitted into evidence, this type of verification, would you agree, satisfies both parts as required by 112.533 of the Florida statutes?
Yes, this is what our labor council advised us to do.
Okay. The Labor Council, is that Mr. Wood or Mr. Schroeder? Okay. And so this was done in January 5th of 2021, this year, correct?
Yes.
That was even before the decision, the award by Mr. Schulman in March, roughly 2 months later of this year, correct?
Yes.
So this department began making the changes even before the decision by Mr. Schulman, which found that a verification requirement was lacking for Malera.
Yes, because you brought it up in
And as we sit here today, the city's proffered exhibit in this case that Arbitrator Finnegan is going to be evaluating in his time to deliberate over this, this is City Exhibit 5, still is statutorily deficient. Is that correct? You look at the last page of City Exhibit 5 in the black notebook. Black notebook. The one.
the, yes, based on the arbitrator's ruling, he said it was deficient, you said it was deficient, so we tried to correct it.
Well, but look at the last page of Exhibit 5 in the black notebook, Chief. What I'm talking about is now we're into Officer Goins. That final page of this signed off statement is, again, not in compliance with the Florida statute, correct? Doesn't have both, he's not.
It doesn't have the things that the.
Right. He's not verifying that he knows that everything is truthful and accurate in that report, correct? He's not verifying the truthfulness of the act.
He's swearing and affirming under the penalty of perjury that to the best of his personal knowledge and information and belief that he has not willfully, knowingly or willfully deprived or allowed another to deprive the subject of the investigation of any of the rights contained in 112.532 and 112.533 Florida statutes.
Right, but
And he signed that.
and if you want to turn to tab 37, he didn't put in the first part as required by statute.
That's correct, sir.
That is, that the contents of the report are true and accurate based upon his personal knowledge, information, and belief, correct? And if he were to do that now, well, strike that. But yet the discipline, your recommended termination came based on the report, which is City's Exhibit 5, correct?
Correct.
And we know that the statute says behind tab Exhibit 37, Union Exhibit 37, would you agree, Chief, says the requirements of subparagraphs 1 and 2 shall be completed prior to the determination as to whether to proceed with disciplinary action or to file disciplinary charges.
That's what it says.
Yet, with that being the law, nonetheless, Officer Goins was terminated based on that IA report from Lieutenant Milan, correct?
Correct.
And Lieutenant Milan is still never been disciplined or even placed under investigation for violating now 2 officers' rights in the way that he wrote their reports, correct?
That's correct.
Now, I just want to cover one last thing with you, Chief. Do you expect your officers under your command to follow the law?
Yes.
Do you expect your officers under your command to follow the policies of the department
Yes.
and the policies of the city?
Yes.
Do you try to do that yourself?
Yes, I do.
I want to show you one exhibit that has not been entered into evidence yet. No, I can show it to them first before I show it to you, right? This is it's a CJSTC form and some emails related to that. Have you seen these before, Chief?
Yeah.
Okay. You're identified on the second page with Rebecca Ackerman and some of these emails.
I'm going to object to these at this time. This looks like now we're introducing things that could have been exhibits in the Malero hearing.
I'll explain the, I guess I should just show it to you.
before I even look at this, is this an exhibit that you guys
No.
exchanged pre-hearing?
No, sir.
Is this something you just came up with?
Yes. Just as they did with the
City maps?
city maps.
Okay.
I can-
So what is this, Mr. Wilson?
Okay, on direct, you heard Mr. DeRozier question him about a CJSTC Form 61. What I have for you is a CJSTC Form 61, as well as the emails that relate to its submission to the state. So you just saw a CJSTC.
Officer Goins case?
Yes, and this is one related, this is in Malero's case, and it has some relevance to some of the charges in this case. If I can have a moment to try to
Okay.
link it together.
Okay.
Okay. Chief, what you have in front of you is a series of emails about the CJSTC form affidavit of separation, which is the last page. And do you recall submitting the affidavit of separation for Malero just as you did for Officer Goins?
I do not submit these. If
Okay.
you ask me if I recall signing it,
Okay.
yeah, that's my signature.
Okay. What's been admitted as Exhibit 13 on your direct just a few minutes ago was the similar form and other attachments for Officer Goins. Do you recall that?
Where was this now?
Turn to tab 13
Your black.
in the black notebook.
Okay.
And you had a Form 78, which is a different form, in Internal Investigation Report, but right behind it was the affidavit of separation. Do you see that, sir?
Yes.
And what I've now submitted to you is the same form for Officer Malero, correct?
Yes, it would be the same 61.
Okay. And I know you were in the military, Chief, but it's my understanding that a CGSTC form is kind of analogous to, in the military, they call it a DD 240, 214 form?
I'm sorry, could you repeat the name?
Is it a DD 214 form? Have you heard that before?
Yeah. Yes.
Is that the discharge papers for someone in the military as to what the manner of discharge, whether it was honorable, dishonorable, at what rank?
Yes.
Okay. Isn't it true that the affidavit of separation is analogous for a police officer to what that form is for someone in the military?
It would appear it's a similar.
Okay. And the reason I wanted to ask you about this after your direct from Mr. DeRozier's is it looks like you signed off on Officer Goins. I'm again looking at Exhibit 13, page 2. And you signed off on it on August 1st and had it notarized on August 1st, correct? Or you took an oath, it looks like, right, and signed this?
Yes.
And in front of Chelsea Weber. Is she someone that works here in the department?
She used to be a lawyer.
Okay. And you signed off on this form and swore to it, correct?
Yes.
What I'm asking you about here in the case of the new exhibit, which it looks like, correct me if I'm wrong, for Officer Malero, you signed it on December 10th of 18, but then had it sworn to on December 19 of 19.
Yeah, I think that was an error by the notary entity because, well,
But don't the emails discuss that, Chief? Don't the email chain, doesn't the email chain?
yes, they do.
Here's what I'm getting at, Chief. You expect your officers to not falsify a report of record, correct?
Correct.
Even if this is the wrong year on the one you signed for Malero, even if Chelsea Weber was wrong, it was December of 2018, you're still off by 9 days.
Yes. So it appears.
So either way, if you're either off by a year and 9 days, or you're off by 9 days, but the fact is you didn't swear to this under oath, this form for Officer Malero in the presence of Chelsea Weber, did you?
I don't recollect that. I may not have.
And yet one of the
I may
charges,
have and did not notice days.
But yet you find fault, you have found fault, so much to recommend the termination of Officer Goins based on allegedly falsifying a report, correct?
I'm sorry, ask me that question.
Yeah. Part of your basis of recommending the termination of Officer Goins is that you believe he falsified a report, correct?
Yes, among other things.
And this appeared, you don't have a rational explanation or a reasonable explanation as to you allegedly swearing to something in the presence of someone either 9 days off or a year and 9 days off, correct?
Objection, that mischaracterizes testimony.
I don't believe it mischaracterizes testimony. Did I misunderstand you, sir?
Hang on.
I can re-ask it to try to make sure I'm not mistaken. You said you don't have an explanation for why you either claim you swore to something in the presence of Chelsea Weber either a year and 9 days or 9 days if her year was off, correct?
She's noted here that it does not swear in the presence of, it says personally known. So I don't.
You can't do an oath to someone who's not present, can you? That wouldn't be something you would allow in the police department by law, would you?
No, I wouldn't think so. I'm not really familiar with,
Okay.
there's, in Florida, it seems everything has to be sworn to and,
Yes, sir.
yeah. So
Okay.
I'm not really familiar with that, in all honesty.
This time I'd like to move this into evidence as Union's Exhibit 43.
I object based on relevance and prejudice. I don't understand what he's trying to establish if he's not trying to establish that Chief Umberger maybe did something wrong in the past and therefore it's likely that he did something wrong now. Again, I think the rules of evidence prohibit that type of evidence.
I haven't excluded any evidence. I'm not going to start now. I will admit Union Exhibit 43. Over objection, and I'll give it the weight it deserves.
And lastly, Chief, I want to go over with you. This officer to my left, Officer Goins, he's on the Brady list, which you've explained on direct, makes it difficult for him now to go to court and testify in cases, correct?
He is on the Brady list? I didn't know that.
There's some emails, I'm trying to speed this up, but one of your email exchanges, or either it came from Deputy Chief Batten, said we better be prepared to put him on the Brady list. Do you recall seeing anything like that?
I don't recall. We don't put people on Brady lists. The state attorney does.
The fact is, though, that he is on a Brady list now. Do you have any reason to dispute that?
I don't know that. You're telling me you know he is?
I'm referring to an email that is one of the emails in our exhibits in this case.
Yeah, I don't recollect that.
Okay. If he is on a Brady list right now, which makes it difficult for him to testify, that would be as a result of him being charged with untruthfulness by this agency, correct?
I don't know that I can answer that. I don't know why I mean, possibly.
Okay. Do you know if it's on the Form 78 that he would be placed on a Brady list? Do you have any knowledge of that? As a moral character violation?
I'm not sure what your question is there.
Yeah, does anything on Form 78 as a moral character violation indicate to you that would place him on a Brady list?
No, I think that's a completely independent thing, review that the state attorney's office does. Nothing to do with FDLE, to the best of my knowledge.
And Chief, did you have anything to do with the state attorney's office being sent copies of the internal affairs investigation in this case?
No.
Do you understand what a Garrity warning is?
We When you say anything to do with,
Did you respond to a request, tell someone to send the IA report, and do anything?
I believe I told Deputy Chief Batten that he needed to notify FDLE of the fact that we had a sustained violation of untruthfulness, possibly affidavits of probable cause that were, incorrect, falsely
Okay.
produced, and have him refer that to investigation if they wanted to accept it. So I didn't tell him to send any.
Do you agree that, with the premise of what Garrity is, and that is that anything that an officer says can't be used against them for criminal
Yes.
prosecution?
Yes.
But yet you've seen the letter from Ashley Terwilliger that's behind tab 26,
I
correct?
saw that.
And apparently someone within this agency, your agency, sent copies of the internal affairs investigation to them for purposes of seeing if there was a basis to pursue criminal charges for perjury, correct?
That's what it appears like, yes.
And you're telling us here on the road, you don't know how that happened, correct?
I do not.
Now, one thing we do know that there is some email traffic for you from is behind tab 42, and that's your email exchange with Jason Creeksman of the FDLE.
Yes.
If you look behind tab 42, is this your email exchange that you had with Jason Creeksman about having the FDLE look into this matter?
This is an email between me and Jason Kriegsman, basically asking him who was conducting the investigation. We had two different things going on at that time. Paul Turner was mentioned, and also Goins on the floor. And I knew that Gary had reached out to FDLE on both of those matters, and I was trying to find out where that process was, and who was doing the investigation.
Okay.
And so that's when I learned that FDLE was conducting the Turner investigation, and he says, I believe the SAO is reviewing the other case. And that was the first that I had any notification that SAO had that.
And then on August 14th and 19th, you see your email on page 1 of this exhibit, where you say, I'm out of state until Sunday. I understand that FDLE is conducting the investigation in Paul Turner, and that SAO has got Goins and LaFleur's investigation. Is this correct?
Yes, that's because I recall, that jogs my memory. Gary told me that, but I was just trying to confirm that, because I felt that odd. I didn't understand why the SAO had Goins and LaFleur's, and because to my knowledge, Gary referred both of these cases to FDLE,
Okay.
because that's where we always start.
Were you seeking to have the certificate, or were you, strike that. Were you seeking to have the certification of Officer Goins evaluated for potential discipline against the certification?
No, I merely filled out the 61 form as I'm required to do, and then we're required by FDLE to send that in. I wasn't seeking anything.
Okay. Isn't it true that the FDLE conducted an investigation on Mr. Turner, but not on Mr. Goins?
I don't recall, I mean, it says that FDLE is conducting the investigation into Mr. Turner, and the SAO is, I assume, doing Goins and LaFleur.
Okay. At this time, I'd like to move Exhibit 42 into evidence.
No objection.
Exhibit 42 is accepted in the evidence. As you need Exhibit 42.
Okay. And then lastly, Chief, I do want to just touch on this prisoner transport policy. You do have a prisoner detainee transport policy, correct?
Yes.
And I know you've gotten a chance to see it through other witnesses already, but it's behind tab 31. It's now Exhibit 31. This is a policy that you issued back in October of 18 for this department, correct? For the department.
Yes, sir.
And on page 2 of this policy, under 5.6.1, it does state that an arresting transporting officer is to thoroughly search each prisoner, and that applies to all transports, correct?
Yes.
In fact, you even apply this in a separate policy to persons Baker Acted, correct?
Yes, that person's legally being taken into custody.
So, same thing I asked Lieutenant Milan, I want to see if you agree with your Internal Affairs Investigative Lieutenant. I said, so regardless of whether there was it was a legal search or an illegal search when Officer Goins found the cocaine on Mr. Staff, he was going to be searched before he was transported away, correct? By this policy.
So you're saying that it was inevitable he was going to be searched?
Well, he was cuffed. There were charges already. You saw the testimony for LaFleur said he was going to charge him with resisting, independent of the narcotics charge, correct? We pointed that.
That's what LaFleur told Internal Affairs.
Yes. And obviously you weren't there that night. You're just watching a BWC, but it would have been negligent on these officers' part to leave this guy in the state that he was in, just wandering around the streets of downtown DeLand at 1 a.m., correct?
That's right. This policy contemplates that. This doesn't say, you know, let me explain the policy. It doesn't supersede constitutional law. It doesn't you can't just search somebody because they're getting in your, if you're giving somebody a ride, so in this case, if he was not under arrest and he was intoxicated and they felt they should take him somewhere, you know, to a home or safely, they don't have a right to go in his pockets. They have to ask him for consent to do that. They can say, sir, we can give you a ride, but our policy is if you get in the car with us, you need to undergo a search of your person. And he has a right to refuse that search and say, no, I don't want to do that. Well, then we'd have to make other arrangements. We'd have to call somebody there to pick him up or whatnot.
Okay.
You know, and if we ended up ultimately searching him and found that, it couldn't be used as evidence against him.
Okay, I understand what you're saying, Chief, that your policy doesn't supersede constitutional rights. What I'm getting at, though, would you at least agree that you have a policy that doesn't seem to articulate any exceptions? In fact, it says all in bold, doesn't it?
Yes, it does.
Okay. And is it perhaps something that maybe needs some retraining, or especially for an officer who might be a rookie officer?
No, I don't think so.
Okay. And you're saying that as someone with, how many ever years you told Alex on direct that you've got in law enforcement? Was it 35, 40 years in law enforcement?
I'm in my 29th year.
29, okay. So you say that and obviously you're speaking from the person whose name is on the policy, so you certainly know what it means and what it's intended to mean, correct?
Yeah, and this particular section, I don't independently recall rewriting this policy. This could have been a policy that was in effect before I got here, and all they're doing are department accreditation folks from time to time are updating the policies under my signature. So I don't know that there were any changes, and I certainly don't recall making a change that this applies to all transports, or that I made these changes. It's just simply a matter of housekeeping, where at times we're updating policies. There might have been some changes to this, but I don't recall that being a change.
But you expect your officers to follow policy, of course.
Absolutely.
Okay. And the last thing I didn't ask about was the ethics complaint that Mr. DeRochers asked you about. Just to be clear, they dismissed the ethics complaint against you but there was never any hearing or anything of that nature, correct?
That's correct.
It was just dismissed outright as being allegedly legally insufficient, is that correct?
Yes, and that there was no basis for, I forget the wording in the letter that I received.
Okay. It says for lack of legal sufficiency, that was in your city exhibit 11, is that?
That's in the city exhibit 11, but I also received an independent letter from them that spells out some more.
Okay, that's a letter that is not part of this exhibit.
That's right.
Okay, all right. I don't have anything further, Chief. Thank you.
Thank you.
I just have one question.
Go ahead, Mr. Grosser. I think he does have
Yes,
redirect.
yes, sir.
So you just got walked through some questions about that detainee, arrestee, transport policy. Chief, you remember those? Do you know whether or not Mr. Goins or Mr. LaFleur or their representatives at any point during the IA process alleged that the reason they searched Mr. Staff is because they were just going to transport this guy home and they had no intention of arresting him? They just wanted to make sure they followed the policy. Does that sound like something that was made up after the fact?
Objection.
It's the
Leading.
first I've heard.
Hang on. He said objection leading. He
I'll
already answered it.
withdraw the question.
And if my last recross on that same subject, if I may, just one question.
Then he's gonna want redirect if you're getting regardless.
He gets to only ask about that specific topic that I asked.
That's what I was gonna ask, that one
Right, but
question.
you've each had your one recross and
Have we,
redirect.
No, he has not had his
I
recross.
haven't had
I'm sorry,
recross.
I'm
I'm sorry.
sorry.
Just one question, follow what Mr. DeRocher just asked you about the union not bringing up anything about the prisoner transport. Would you agree the union and/or Officer Goins may determine more basis for their case after time has passed? I mean, they may not know all the elements to what they want to raise at the time they have their show cause hearing. Is that fair to say?
Sure.
All right, nothing further.
Chief Humberger, can you go in the black notebook to City Exhibit 6, which is the charging affidavit, the supplemental report. There's been a lot of focus on the IA report and how it got to where it was in the whole investigation, but the officers' charging affidavits of individual Joseph Staff on the night of January 20, 2019, that's what these two documents are, correct?
Correct.
And the first one is the 7th Judicial Circuit Charging Affidavit, Volusia. That's by Officer Austin LaFleur, right?
Officer LaFleur, yes.
Okay. And they handled this incident with Mr. Staff at 1 a.m. that morning, right?
Yes.
And then they go back to the station and write this report?
In all likelihood, yes. I'm trying to see if deduce when they actually wrote it. But, yeah, we're going to have to do the incident.
Okay, well, so for the record, the first 2 pages of Exhibit 6 under the state's no pros is the charging affidavit for the charges against Mr. Staff, right?
Yes.
And who picks those charges that Mr. Staff is charged with? Is it Officer LaFleur?
It would have been him since he's leading the
does he confer with anybody above him and say, here's what I think we should charge, or does he just go back to the station and decide the charges against defendant staff?
He may confer with the supervisor, or he might have conferred with Officer Goins. I don't know that, though.
Okay? I may be showing my ignorance how law enforcement works in terms of preparing their reports to charge someone in the community with crimes. And so who owns this charging affidavit? Officer LaFleur?
Officer LaFleur owns it, yes, sir.
Okay, does he have to get this approved by anybody above him? Because I understand he's a rookie officer at this time, at least what I've heard today. Can he just sign this and submit it with no approval, and this is his charging affidavit?
His supervisor should have his eyes on it and should have.
And who would that have been?
That night, there were two supervisors, Corporal Dave Ergel and Lieutenant McManus.
Okay, and in this middle section where it says the charges against Mr. Staff, charge 1, possession of cocaine. Charge 2, resisting officer without violence. Charge 3, breach of the peace, disorderly conduct. Are those charges set forth in the order of severity, or just how he puts them in the report?
I don't think it requires that you list them in order of severity, although that's probably common practice.
So the most serious charge against Mr. Staff was the possession of the cocaine that was the product of potentially an improper search?
Yes, that was a felony.
Even though I heard testimony that it was a minuscule amount of cocaine?
Yeah, any possession of cocaine in the state of Florida is a felony.
Okay.
Any amount.
And then the resisting officer without violence, that's the second charge. And that's based on whether or not Mr. Staff was belligerent with either Officer LaFleur or Officer Goins. In this case, it's Mr. Goins saying he resisted him as an officer without violence.
No, he's saying he resisted LaFleur.
Yes, this is LaFleur's report.
Goins is saying that he saw LaFleur.
I'll get to that in a minute, but this charging affidavit, the first one we're looking at is Officer LaFleur's charges, and in the middle box, his support for the charges.
Yes.
Okay. And then the third one is the disorderly conduct, breach of peace, right?
Yes.
Okay. And then if we look at the third document in the narrative supplement, this is Officer Goins' report that supplements Officer LaFleur's.
Yes.
And does Officer Goins need to have anyone approve his supplement report, or is this his, because I don't see anyone else's signatures on this?
The supervisor should have reviewed it.
Okay, but do they have to sign off on it?
Yeah, and my understanding is there's issues with the current records management system where it doesn't, for whatever reason, show when an officer goes in when a supervisor goes in electronically. It won't show up on the unbelievably late.
Okay. Well, you testified earlier, when Mr. Wilson brought this up at the start of his cross, that it was good police work, should not have gone into the pockets before the search. But then you went on to say, then the reports, then the lies to support their actions. What reports are you referring to? Are you referring to these charging affidavits and supplemental reports?
Yes, and also the internal affairs, the transcripts with the investigator as well.
Okay, but what I guess I'm questioning is, are you saying that officers before and Goins picked these charges against defendant staff and then found a way to support their charges with their lies?
Yes. I think that I understand your question.
Well, were they overcharging Mr. Staff for what you saw on the body cams, in your opinion?
Yes, I didn't see any breach of the peace, disorderly conduct. I didn't, and again,
I guess what I'm trying to figure out is what comes first, just when you say they engaged in their lies to support their actions, to support their reports. In what process, it seems to me that they go back to the station, write their reports, and determine their charges. And if they're coming up with these 3 charges, and then they fill out the narrative to support the charges, why are they doing that?
well, they came up with the charge, as if you recall in the body worn camera, Officer Goins says, now you're under arrest for possession of cocaine.
I get that part, okay? So that goes to the possession of the cocaine. What's the lie with regard to resisting officer without violence?
That he couldn't have seen, based on the body worn camera footage, he couldn't have seen what he said he saw.
That's Officer Goins.
Officer Goins.